We're live.
Good afternoon. This is the House Judiciary Committee. It's March the 9th, 2021, about 1:30. We're going to go ahead with our docket of 8 bills today, starting with House Bill 1188, Delegate Barron's bill. Delegate Barron will get 3 minutes. Everybody else will get 2 who are here to testify on the bill. We'll hear after Delegate Barron from Nick Maroney, Kim Haven, Eric Sterling, Alonzo Turner-Bay, Anita Wiest, and Tom Cole. So with that, Delegate Barron for 3 minutes, please.
Thank you, Mr. Chair, Madam Vice Chair, and colleagues on the House Judiciary Committee. For the record, I am Delegate Eric Barron, introducing to you House Bill 1188, which would establish a correctional ombudsman in the Office of the Attorney General. I hope this starts a meaningful discussion on how we humanely treat inmates and that you can move the bill favorable. The bill is needed because incarcerated Marylanders face challenges that aren't always addressed in accessing adequate medical care, education, rehabilitative programs, access to the courts, and the ability to practice their faith. Family members also face unreasonable obstacles at times in visiting their loved ones. Volunteers providing services inside the prisons are subjected to confusing and often inconsistent rules from institution to institution. Studies indicate that the more humane and restorative conditions in our prison system can result in better outcomes for recidivism and public safety. The bill, again, creates a correctional ombudsman in the AG's office. The AG would appoint this person with the advice and consent of the Senate for a 5-year term. The ombudsman, among other powers, would be able to investigate complaints, conduct independent reviews and assessments, seek to resolve complaints through mediation, issue reports of findings, and provide annual and other reports and recommendations. There would also be established an advisory board which would provide information and assist in identifying appropriate matters and priorities of concern for the ombudsman. Correctional oversight is critical to assure that Marylanders who happen to be incarcerated are nevertheless safe and treated humanely, and that we respect human dignity even in that setting. Transparency would provide protection from both harm and fear of retaliation. External oversight and review also will benefit administrators by providing objective feedback that they need to make things better within the system. We have examples. In Maryland, we have the Juvenile Justice Monitor Office, which is a good model for the juvenile system. And there are ombudsman type offices in other states, many other states actually. I would offer Texas, Indiana, Michigan, and Florida as examples. So that's the bill. I defer now to my panel, but I hope that you can have a meaningful conversation about this bill and the issues that it raises and move the bill favorable. Thank you.
Thank you very much. We'll hear now from Nick Maroney, please, for 2 minutes. Mr. Maroney.
Hello, sorry about that. Can you hear me?
Yes, go ahead.
Good. Hi, Chair Klippinger. Good afternoon, and good afternoon to Vice Chair Atterbury, members of the committee. Nick Maroney, Juvenile Justice Monitoring Unit, in support of HB 1188. We're an independent state agency, as you may know. In the Attorney General's office, we combat abuse, we ensure proper services in the deep end of the juvenile justice system, and our public reports are available on the AG's website. We support the Correctional Ombudsman's Bill because we know independent oversight of the corrections system will improve safety and services in prisons and safeguard against abuses inside high fences and behind locked doors. Small agencies like ours and the Ombudsman's office can make sure people get proper treatment and services. We do this by performing unannounced visits to facilities, working collaboratively with the agency we monitor, and also reporting the results publicly. So we bring transparency and we bring accountability. Our unit has brought a sea change in the juvenile justice system and led to continuous improvements into the current legislative interest in transforming the system to benefit young people and public safety in equal measure. The Ombudsman's Office can also have an impact out of proportion to its size and to the modest investment of resources needed to make it work. We've heard, though, that the budget may not exceed $100,000. That's what we heard may be under consideration. Considering that the Department of Corrections was just given $1,253,899,854 Maryland taxpayer dollars, that means that the consideration is for less than my math is not as good as it should be, 1,000 perhaps of the department's budget under the plan for the Ombudsman's Office. That's not a sufficient, $100,000 is not a sufficient budget to hire people to do this kind of work. They need pins. They need pins for skilled and determined people to do this necessary work. The pins could come from corrections. That would be one way to do it, and you should actually consider that. We need an Ombudsman's Office to address serious issues before they become chronic issues. Outside oversight helps agencies avert costly problems, and that critical aim is achieved through early intervention and cooperation between the watchdog and the agencies. Big organizations like corrections need people who connect the dots, people from the outside, and they act as an early warning system, uncovering problems.
Mr. Maroney?
Yes, sir.
You need to
Proposing
wrap up.
solutions. Okay. In 2019, the state of Maryland had to pay $1.4 million to settle a lawsuit brought by blind prisoners in the city, forced to depend on other prisoners, resulting in extortion, sexual assaults, coercion of the prisoners' friends and families. A couple of months ago, we learned Maryland is now going to pay another $360,000 to settle a Fed lawsuit because they ignored the Americans with Disabilities Act. Okay, for these and many, many other reasons,
Right.
We would support the bill. Thank you, sir.
Kimberly Haven now for 2 minutes.
Good afternoon, Mr. Chair, Madam Co-Chair. My name is Kimberly Haven. I'm here today on behalf of Forward Justice Maryland in support of House Bill 1188. This bill is critical for moving our country, moving our state forward. This bill provides accountability. It provides transparency to corrections, a department that is notoriously operating in the dark. We can't correct or address what we can't see, and we can't see what they won't show us. This bill will also allow us a mechanism by which we can address serious issues before they become legal issues that will cost the state even much more money, or an issue that becomes, in press and media terms, above the fold. Having been on the inside, I know that there are issues that go unreported because staff, because people that are detained know that there is no mechanism for reporting. There is no mechanism for relief, and I think that this position and this bill is overdue. I therefore urge this committee's favorable report of this bill, and I'm open to any questions that any members may have. Thank you.
Thank you very much. Eric Sterling, please, for 2 minutes. Mr. Sterling. Oh, I'm sorry, he's not in. Okay. Alonzo Turner Bay for 2 minutes, please.
Yes, my name is Alonzo Turner Bay. I was recently released from Division of Correction after serving 31 years, 6 months, 15 days. I ask that this committee vote favorably for Bill 1188 because oversight is needed in Division of Correction because there are many issues that this legislative body don't know about that goes on in the system, that goes unchecked. For example, before I released, the governor handed down an executive order that PPE be issued to all the inmates to protect themselves. It wasn't until I filed a complaint in June that I was given the PPE, and then after I was given the PPE, I was instructed not to let other inmates know how I got the PPE or show them a copy of the write-up that I wrote in order to get the PPE. Another occasion in 2007, I was told it was my job duty and obligation to lock and secure cell doors. I filed multiple complaints. They was all dismissed. It wasn't until I wrote the newspaper that some attention became brought light of this, the Daily Times on the Eastern Shore. And when I wrote the newspaper, in turn, I was punished. I was placed in solitary confinement for 180 days because of the newspaper article. This bill is very much needed to stop the abuse, the neglect of what's going on inside of the prison system in the state of Maryland. I hope someone has questions and I'll be free to answer. Thank you.
Thank you very much. We'll hear now from Anita Weist, please.
Good afternoon. Prior to my retirement, I worked at ECI from 2009 to May of 2019. I worked both as a correctional social worker and an Eastern Regional Addiction Supervisor. At ECI, I saw little treatment being offered to the majority of the inmate population. This problem is not isolated to one prison. Currently, there are only 6 addictions counselors total in all of our state prisons. We should all find this troubling given the drug problems in our communities. An ombudsman needs to investigate what's being said about program supports and what actually exists. As the community advanced addictions treatment and resources in response to the overdose epidemic, I watched the prison system take a lackadaisical approach to this crisis. They can claim it was due to financial constraints, but there's much that can be done without a lot of money. Peer support is one such best practice method. Pennsylvania boasts over 500 peer support workers in 25 of its 26 state prisons. Without proactive measures, the mission of the department to protect the public does not extend beyond the walls of its institutions. Oversight by an ombudsman empowered to make unannounced visits to the institutions could identify obstacles embedded in the system and start holding accountable a system that should be doing more. If you've not already done so, I ask that you read my detailed written testimony. Thank you for your time, and thank you for considering favorable action on this bill.
Thank you very much. Tom Cole, please, for 2 minutes.
Yes, thank you. Tom Cole on behalf of Strong Future Maryland. We've submitted written testimony. I think we've heard one of the reasons why for Mr. Turner Bay, this ombudsman is so important. This past spring, we were told that Maryland prisoners were making masks and other protective equipment, but we didn't know for months about the conditions under which they were making this equipment. And it was only from repeated inquiries from the press that we were able to find out any information. States now across the country, and Maryland is one of few that does not have this correctional ombudsman, are considering not only creating the position, but also expanding the rights and ability of the ombudsman to investigate what is going on in Maryland prisons. Prisons are intentionally opaque. Press cannot get into these spaces. So this is not a matter of not trusting corrections. It's rather making sure that the laws that this body passes are enforced. And it shouldn't be that members of the General Assembly need to find out what is happening in Maryland prisons from the press. You should have the ability to reach out to the Attorney General's office and this ombudsman. So we have Marylanders, and they are Marylanders that are behind bars, and they deserve the right to have the protection of our laws. They deserve the right for us to know what is happening in our prisons. So we would strongly support this bill and request a favorable report. Thank you very much.
All right, we're going to go back to Eric Sterling, and I think we'll go ahead and ask Phil Karoum and Ann Seacott to come in as well. So if we could have Eric Sterling now for 2 minutes.
Thank you, Mr. Chairman. Delegates, I think that the essence of my point is you want appropriate checks and balances. We have, I think, a outstanding leader in the Department of Public Safety and Corrections, but it's very important that there be an independent opportunity for oversight and to both to look at issues that are raised and to respond to the concerns of both staff and people in custody. It's unfortunate that there have been, since 2008, at least 5 major criminal scandals involving the Department of Public Safety and Corrections, in which numerous officers were indicted in April 2008, April 2013, October 2016, November 2017, April 2019. It's important that the state have its own independent ombuds, and I urge a favorable report.
All right, if we could have Phil Karoum, please, for 2 minutes. Judge Karoom.
Sorry, I was unmuting.
Great. 2 minutes.
Members of the committee, speaking again for Major and not for the Maryland courts, I'd like to give 4 quick examples of the need for independent review for the many problems in our Maryland prisons. One of those involves volunteer teachers in the prisons. An example is a group of volunteers in 2019 sent a birthday card to a prisoner, unaware that there was a rule against social contact. They were all banned for a period of 2 years from volunteer teaching, and their only recourse was to appeal to the same warden who had written the harsh and inadequately published rule, who denied that appeal. Prisoners can only seek initial review from the same sergeant in charge of a block, or from, after that, a hearing officer who is another department employee with, in effect, a deck stacked against them. The Correctional Standards Commission that is pointed to by the department as a source of review actually is a system where one department employee inspects other department employees with months of advance notice and a well-known checklist. If there are any problems, the only sanction is a warning and another review that occurs months later. The last and most important example is healthcare, the single largest category for action by ombuds offices in other states. In Maryland, the COVID-19 situation is a glaring example of where this was needed, as other witnesses have said. In, for example, Eastern Correctional Institute, there were complaints over a period of time from prisoners and their families that correctional officers were not wearing face masks. No action was taken until finally an entire shift of correctional officers, 63 positive infections in 1 week occurred. In other states with ombuds offices, the ombuds were in daily contact with correctional administrators and large-scale outbreaks were avoided. So for all these reasons, we believe it would be a savings of health, of money, and reduce the volume of complaints.
Judge Karoom.
Thank you very much.
Thank you very much. Ann Seacott, please, for 2 minutes.
Thank you, Mr. Chairman. Members of the committee, I'm Ann Seacott. I'm representing the Maryland chapter of the National Council on Alcoholism and Drug Dependence in support of House Bill 1188, asking for one small amendment. We thank Delegate Barron. It was under Delegate Barron's leadership that in 2019, Maryland passed groundbreaking legislation for the country in requiring that all local detention centers in the state provide over the course of several years medication-assisted treatment to people with opioid use dependence. That is happening. More and more local detention centers are doing that. Unfortunately, the state corrections facilities and as a state agency, they have not yet embraced this very sensible and nationally recognized best practice. So we absolutely want to see an ombudsperson be able to look at numerous things, including healthcare. And in the bill where healthcare is mentioned, mental health is mentioned, and we ask that substance use disorders be added into that as an area for the ombudsperson to be able to investigate and report on. We think that transparency makes sense, and we think that the better that we're able to treat people, treating however, whether it's medically or not, the better that experiences will be for their families, for themselves, obviously, and then have benefits down the road too, in terms of hopefully getting people's root cause problems addressed so that they're able to live successfully in the community. So we thank you, Ines, for that favorable report.
Thank you very much. Questions for the panel? Delegate Fisher.
Thank you, Mr. Chair. Oh, can you hear me? Oh, thank you. Thank you, Mr. Chair. Thank you, Delegate Barron, for your leadership in this area and many others. Our committee remembers the fresh smelling paint when we went to visit Jessup, which I'm sure they painted the day before we got there. My question is for you, and maybe Mr. Turner Bay can enlighten me on some of it. In the position itself, I saw the reasons for good cause, that it could be terminated by the AG or a 2/3 vote within the legislature itself. But is there ever going to be sort of like, I don't want to say a term limit, but an end in which someone could serve in this job? You know, if the Attorney General keeps appointing the same person for like 20 or 30 years, is that any kind of concern to you? And then my other question, which would be for you and Mr. Turner Bay, would be how would an inmate directly contact them for concerns, and like what kind of staffing would this position have, so that an inmate wouldn't have to go through? I guess I don't know how that technically would work when there is a complaint or an issue, to make sure that it is addressed appropriately. So for both of you, thank you.
Thank you, Delegate Fisher, for the questions. Term limits, I wouldn't have any problem with term limits for the position. I think the Senate confirmation is a check on that, and having like the wrong person being reappointed over and over again. But I do get your point, and you know, it's always nice to have a fresh perspective on, particularly on issues as important as we have here, and not somebody that's just kind of getting stuck on doing things the same way over and over again. So I would be happy to defer to the committee on whether to have a hard and fast limit of terms for an individual, or whether the legislature as a check and confirmation would be enough.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, committee. For Mr. Cole, you said the inmates were making PPE equipment, and you mentioned briefly under certain conditions. Can you describe the conditions you're talking about?
Well, actually, that was the issue. And I believe it was another one of your members, Delegate Mosby, who had numerous inquiries about the conditions under which this equipment was being made. And I don't believe he was responded to in a timely manner. I think that there's still some opaqueness as to what conditions under which this protective equipment was being made, or whether or not the inmates that were making this equipment were doing it under conditions consistent with what other workplaces were ordered to follow at the time.
Who was the equipment being made for the inmates, or?
I believe it was made for general distribution by the state.
Thank you very much.
Thank you.
The Health and Government Operations Committee, Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you, Delegate Barron, for this bill. Years ago, I used to serve on the Correctional Standards Commission, and my question is to the point of how would, and if, would this ombudsman be able to utilize the reports that are completed through that mechanism to help shape their work? Just curious, because I know in that process, they also interview inmates and do some additional work with the daily counts of syringes, et cetera. But I was just curious, how would that play in together? And the last thing, I'd just like to make a statement. Thank you, Mr. Turner Bay, for your testimony. And I did read your article in the Daily Times, because I am from Salisbury, but thank you for that information. Delegate Barron.
Thank you, Madam Speaker Pro Tem. So I think they would work very well in concert with one another. The ombudsman, that information would certainly be among the items that person would have available to them, and should and would use in deciding how to go about their day-to-day, week-to-week, month-to-month work under the responsibilities outlined in the bill.
Thank you.
Delegate Cox.
Thank you, Mr. Chair, and Delegate Barron, good to see you. I am following up on the Speaker Pro Temp's question in a related issue, how this bill would interact with the OIG for DCPS, particularly in regards to, and what I see here, and correct me if I'm wrong, that it looks like the ombudsman will have the same powers of the OIG for assessments, investigations, and inspections, but appears to be establishing a mediation process within this ombudsman office, and then separately we'll have a board. So could you help me understand how that was how that's intended to interplay with the OIG, the Office of Inspector General?
Sure. As near as I can tell, the internal Office of Inspector General within the department isn't anything like what we would normally think of as an Office of Inspector General, and certainly isn't independent. None of us have, to my knowledge, have ever heard from the Inspector General within the department, which is certainly a big key element of this kind of office, whether you call it a OIG or ombuds, is independence. And this position would have the independence to go at issues that the agency is not, and go at issues that that nevertheless are important, and that the public and that the legislature, frankly, should know about, the governor's office should know about, and could move, depending on the issue, to fix and correct.
Okay, thank you.
All right, thank you very much. Further questions from the committee for this panel? Seeing none, we thank you all very much, and that concludes the testimony for House Bill 1188. We appreciate your testimony today. I'm going to move now to I understand I need to go to Delegate Kipke's bill, because Delegate Feldmark got pulled away. So we're going to House Bill 1236, Delegate Kipke's bill. And it's Delegate Kipke and Vince McAvoy to testify on the bill.
Thank you, Mr. Chairman. I appreciate your time. It's good to be with you. House Bill 1236 would, through the State Attorney General's office, it would create a unit to assist Baltimore City in the prosecution of exclusively violent crimes. The governor has signaled that this is something that he wanted to do to help out and be supportive of the issues, the violent crime issues in Baltimore. You'll see, you should have testimony from the governor's office, a letter of support, and their willingness to fund this initiative. I could go on and on about the seriousness of which the Baltimore, Maryland's largest city faces, what is certainly some very sad statistics. And as someone who loves the city and frequents the city, I want to do all I can to be supportive of addressing the violent crime problems that we have there. Personally, I've supported many bills, including some from Delegate Learman and others, to be creative in looking at ways to systematically address the problem. But I do believe we need to do more as it relates to addressing violent crime. So with that, I'll conclude and answer any questions.
All right, Vince McAvoy, please, for 2 minutes. All right, we don't have Mr. McAvoy, but he is registered to support for the bill. Does anyone have any questions for Delegate Kipke? All right, seeing none, we thank you very much, Delegate Kipke, and that concludes the testimony on House Bill 1236. I'm sorry, wait, Delegate McComas raised her hand. Delegate McComas.
Thank you, Mr. Chair. I was a little slow on. Delegate Kipke, I want to ask you, why do you feel that this is a better answer for dealing with the horrible crime situation in the city than just, maybe giving the Baltimore City State's Attorney's Office more manpower or more money or more money to the police department?
Well, I don't have all the answers, Delegate McComas, but I do know that there is a issue as it relates to the number of cases being prosecuted in Baltimore City. I don't know what the reason for that is. However, seeing that there was a willingness in the Attorney General's office to do this, and seeing that the governor is supportive from a funding perspective as well, I thought that this might be a good approach.
Thank you.
Thank you very much. Are there further questions for Delegate Kipke? Seeing none, we thank you very much. Now,
thank you.
The testimony on Delegate Kipke's Bill 1236. Can we go? Okay, we're going to House Bill 896 next. Delegate Mangione, are you here?
Yes, can you hear me?
Yep, we can hear you. 3
Great.
minutes to present 896. Go ahead.
All right, thank you, Mr. Chairman, members of the committee. HB 896 is a cross file to Senator Bailey's SB 268. It's simple but important bill. It expands slightly the definition of a crime of violence found in the criminal law. To explain, in Maryland, a child for child abuse purposes or those under the age of 18 under existing law. If one commits sexual child abuse on someone under 13 years of age, it is a crime of violence. So this bill would raise that age to 16 years old. So this change basically strengthens Maryland's criminal laws by making sexual abuse of a minor between the ages of 13 and 15 a crime of violence, which subjects offenders to additional criminal penalties under Maryland law. So just to think about it this way, it really is hard to imagine anything, of course, more violent, despicable than sexual assault of children. But the way the current law is written has really determined that minors who are 13 and older basically don't suffer the physical, mental pain and trauma in the same way and shouldn't warrant the same protection as children 12 and under. That really is how this is a bill that is a common sense change. Basically, all minors who are sexually abused, I think, should receive the same protections as other victims of serious crime, and individuals who sexually abuse minors of any age should be subjected to the same enhancements and penalties as other violent offenders. So that's it. Again, I think this is a logical, common sense change, and I urge a favorable report. Thank you very much.
Are there questions for the delegate? Seeing none, we thank you very much. And we'll move now then to House Bill 438. Oh, wait, I'm sorry, did I miss one?
I had a quick one, Mr. Chair.
All right, Delegate Cox.
Thank you, Mr. Chairman and Delegate for bringing the bill. I just appreciate the bill very much. Wanted to know if you had a status on the cross file, if it is still in committee or what the status might be, if you know.
Yes. Thank you, Delegate. I'll find that out. I actually have not spoken to Senator Bailey, but I'll get the answer to that. I don't know if there has been a vote on it.
Okay, thanks much.
Yeah. Thank you.
Further questions? Seeing none, that concludes the testimony on House Bill 896. We'll go now to House Bill 438. Delegate Mangione, please.
All righty, thank you again, Mr. Chair. Here to present 438, which has been titled the Monument Protection Act of 2021. To start off, I'll take you back July 4th of last year. I was basically at a cookout. My phone kept going off with messages and calls, and sent a Twitter video showing what was a mob destroying the iconic Christopher Columbus statue in Baltimore's Little Italy, which is a historic piece of art. It's a piece of culture, a piece of pride, especially to the Italian American community. but also to many Americans, and it was completely destroyed. I, on a side note, have family members and many friends who helped donate to pay for that statue. It's very important to note there was advance warning that the statue was under threat. The intent was very clear. The mayor and the police were unfortunately they ordered the police to stand down rather than to allow them to do their job. And to my knowledge, no one has been arrested. So it was truly a shock and display. I mean, for those who are not familiar, it was an example of total anarchy, almost the equivalent of if a mob of people came to the Capitol and started destroying the historic statues in our beautiful State House right up the street. It's unfathomable to think that this would happen. So this bill, this Monument Protection Act, is all about decency, respect, and living in a civilized society. Number one, we can't have mob rule. Number two, you don't get to destroy public property because you don't like it or disagree. Number three, lawless mobs don't rule, and we do live in a civilized democracy. And what happened was complete anarchy, and it wasn't a protest or a demonstration. So this bill, what this bill does is basically takes that type of just horrible behavior and it provides for ramifications of stricter punishments. And it's laid out very simply if you take a look at the fiscal note what those punishments do. There's mandatory minimum punishment for going after these historic statues, monuments, and memorials. So I urge you to vote favorable for this as well, and I appreciate your time.
We'll hear now from the witness, William Martin, please, for 2 minutes.
Yes, I'm here. Good afternoon, everyone. Can you hear me okay?
Go ahead.
I'm here to testify on behalf of Delegate Mangioni's proposed House Bill HB 438. I am supportive of this bill because I believe that it will help deter the destruction of historic statues, but for the property of individual organizations. I'm an officer of the organization that has ownership.
Martin, you are breaking in and out. It's very difficult to hear you. If it's possible for you to either move the microphone closer to your mouth, or I'm not sure exactly how to do this, but I'm going to let you start over, but you broke in and out throughout your testimony.
I'm sorry.
Again.
I hear a little background from someone there, but
if you're hearing background, then you need to close the YouTube link that you may have had open to listen to what was going on.
Let me try that. How is that? Is that better?
That's better. Go ahead for 2 minutes.
I apologize.
No, that's all right.
Once again, I'm in support of this bill that Delegate Mangioni has sponsored. I started to say that I hope that this bill will deter the destruction of historic statues, which are the property of individuals, organizations, and governments. I'm an officer of the organization that has ownership of the Christopher Columbus statue that was destroyed in Baltimore's Little Italy Piazza on the evening of July 4th, 2020. In the weeks prior to the statue being destroyed, there was a group threatening the statue through social media. We tried to get in touch with them. Through some interviews I had on television and newspapers, I tried to reach out to that organization. We were willing to discuss the issues and consider the alternatives, but we could not find out who was in charge, who were their officers, or the leaders of that group. We were willing to remove and relocate the statue. So I believe that this was a legitimate group organization. They would have taken the opportunity to have an intelligent discussion with us. But I'm not here to discuss Columbus specifically. I'm using this as an example. I understand that there are differences of opinion about historical figures today. But a lot of times it's very hard for us to know what the truth is of events that took place 500 years or more ago, some 100 years ago. So how do we judge those figures based on today's way of life? Historically significant monuments are erected to recognize and remember the good and great things that people did and for events that shaped our history, our country, and our states. Unfortunately, there will always be some who will always want to find the negative side and push it instead of recognizing the positive side. But rather than take the destruction of these statues, there should be a discussion, an intelligent discussion, and respect for the owners and artists who spend time and money to put them in place. That is what is missing in today's society. Respect. We need to respect each other. We don't have to like everything and we can disagree, but be respectful of the rights of others. Please keep in mind as you consider your vote, this will apply to new and upcoming figures and events. There will be future statues and monuments erected to recognize them. It'll only be a matter of time before someone finds something that they don't like about them. So let's protect future statues as well.
Thank you, Mr. Martin.
Thank you for your time.
All right. Go to Vince McAvoy, please, for 2 minutes. Mr. McAvoy?
Thank you so much, committee. I appreciate it. Pardon that. I want to testify in favor of Delegate Mangione's bill. I thank him so much for bringing it. I thank you for the courage to show up in Baltimore last summer. Can you all hear me all right?
You have 1 minute and 40 seconds remaining.
Great. You can hear me okay, though? Good. So I just think that, you know, when I look at this from a property standpoint, a dog, you know, understands property rights. I just think that the approach on this has been very negative, very divisive. We have rule of law for a reason. We're either going to have law or we're not. We're either going to have our anarchy and everybody just do as they please, or we're not. And these are property values in excess of $250,000. It was a historic time when it came, but it goes for anything. In other words, we don't do this in this country where we have a sweeping change of emotion in the country and we just wipe out whatever the last 20 years was. We don't do that. We've never done that. So I'm hoping that cooler minds will prevail. I'm disturbed that we didn't have enough people, that we had actually had people coming from out of the city to speak to some of these issues, because it's going on all around the state, all around the country, unfortunately, where people are just taking it upon themselves to redecorate our country. That's not how we do things. We're a civil society, and we need to remain staying civil and work through the process, whatever that process is. Not like the process, work the process. Can't work the process, move. Thank you so much for your time, committee.
Thank you very much. Are there questions for the panel? All right, seeing no questions, that concludes the testimony for House Bill 438. We appreciate your time today.
Thank you.
We're now going to go to Delegate Feldmark and House Bill 1233. I think I saw Delegate Feldmark return, correct?
Yes, thank
All
you.
right, that's fine. So Delegate Feldmark will get 3 minutes, and then we'll go here and we'll hear, oh, there are quite a few. Well, let's go ahead and do that. We'll pull in everyone who is listed as favorable or favorable with an amendment, then we'll hear from the opponents. So Feldmark, if you'd like to begin for 3 minutes, and then we will hear from Kim Haven, Nicole Hanson-Mundell, Akita Jones, Christopher Dews, Gail Thibodeau, Leslie Overholser, and Ricky Mannon and Rich Gibson. That would be fine. All right, off you go.
Great. Thank you. Good afternoon, and thank you, Mr. Chairman, Madam Vice Chair, and committee members. I'm pleased to join you today to present House Bill 1233, the Reentry Success Act. This bill is very similar to a bill I brought before you last year. The primary difference is that several provisions regarding obtaining identification documents were adopted last year in Senate Bill 77, so those overlapping provisions have been removed from this bill. The goal of the Reentry Success Act remains the same, however, to support the stability and success of our returning citizens, both to improve their quality of life on the outside and also to reduce recidivism. We aim to do that in 2 key areas. One is ensuring that every individual leaving incarceration does so with fundamental supports in place to help them transition back into life in the community. Basics such as assistance for food and health care, transportation, and a transitional supply of medications. The other is by offering incarcerated individuals approaching their release date the opportunity for reentry mediation, which is an opportunity to rebuild and strengthen a key relationship that will be critical to supporting their successful reentry transition. Reentry mediation is a powerful tool shown to decrease recidivism. It is voluntary, it is neutral, and it is confidential. It is also important to note that it is not victim offender mediation. I want to take a minute to acknowledge and address concerns raised by victim advocates. I understand, appreciate, and wholeheartedly agree with the concern that requesting mediation must not be used as a way to contact a victim, potentially intimidating or re-traumatizing that victim. Currently, there is an extensive screening process in which DPSCS checks to ensure that mediation requests do not include any individual who has a stay away, protective, or no contact order, or who has requested victim notification. In addition, after completing this DPSCS screening, the mediation program has an additional screening process to ensure that even if an individual is not identified as a victim, there are additional safeguards to identify any potential intimidation or other power dynamics which would make the relationship inappropriate for mediation. While these safeguards are actually essential to reentry mediation, I realize the legislation as drafted fails to address them. I will be requesting an amendment to codify such procedures to guard against any potential misuse of a request for mediation, as well as to correct language referring to incarcerated individuals and make other clarifications. I hope to have a finalized amendment submitted to the committee soon and ask for your favorable report. I'm happy to answer any questions. Thank you.
It helps to have things work. All right, thank you very much. We'll hear from Kim Haven now for 2 minutes, please.
Good afternoon again, Mr. Chair, Madam Chairwoman. My name is Kimberly Haven. I'm here today on behalf of Forward Justice Maryland and Reproductive Justice Inside in support of House Bill 1233. Also speaking as somebody who has been formerly incarcerated, reentry is hard. Reentry is difficult. Reentry is fraught with all kinds of problems that you're not prepared for. This bill will at least make giant gains in trying to help people get set up to be successful upon their return. To be able to leave with a coordinated care, with some sort of transition, ultimately will lead back to safe reintegration into the community, which sets not only the individual up to be successful, but their community as well. Right now, people are leaving prisons and jails without any kind of supports. They're leaving without the crucial things that they need. We know that some people are getting medication. We know that some people are getting documents. The majority are not, and COVID has posed a new barrier to that. And so this bill will go a long way in ensuring that while we have people in our care, custody, and control, and those of you that are on this committee that know me know that I hate to use correctional language, but that's what it is. When someone is in our care, custody, and control, we have an obligation to provide them with the things that are going to set them up to be successful. It will impact recidivism. It will impact someone's ability to transition back into the community, to become a full-fledged citizen again, to be a mom, a dad, an aunt, an uncle, a brother, a sister. And all of that is so crucial. We have the ability to do this. This is not rocket science. Reentry is hard, and this bill will make things a little bit easier. I urge this committee's support of House Bill 1233, and I'm happy to answer any questions about this.
All right, Nicole Hansen Mundell.
Hi, good afternoon. My name is Nicole Hansen Mundell, the Executive Director of Out for Justice. We are a nonprofit that is led by formerly incarcerated individuals whose focus is to educate, engage, and empower the reentry and the incarcerated community around the legislative process. As my colleagues mentioned, we are in full support of this legislation. We stand firm in believing that this legislation helps to fill the gaps of prior legislation that was passed by Senator Ellis last year that goes really comprehensively into this idea that individuals should have their Social Security cards, the real ID, and all the necessary documents. And even that legislation really helps to bring the agencies together to make this happen. And that is what's often missing in our policy, is that the really thought through implementation of how this thing will work. This bill kind of supports and helps to fill in the gaps of that. We also support with amendments. We talked with the delegate a few weeks ago about some of our concerns in the bill, and especially in reference to the if qualifying component. How wouldn't someone who's been in prison not qualify for government assistance when they're literally coming home to nothing? And we think that language would seek to push people away from qualifying, and we just want to make sure that the reentry coordinators on the inside sole job is to make sure that they go to the person on their way home and get them set up for the application process. And so for these reasons, we stand in support, and we hope that you all will support legislation that helps to prepare people coming home from our prisons and jails get set up for success.
Thank you very much. We'll hear now from Akita Jones, please, for 2 minutes.
Hello, I'm Akita Jones, and in my experience as a mediator, I've seen how reentry mediation gives incarcerated individuals the opportunity to have conversations that are oftentimes difficult and necessary, and the opportunities to make plans for the future. These inmates are able to mediate with whomever they identify as their support on the outside. And this could mean parents, partners, siblings, friends, family members, or whoever they need to meet with in order to help secure their success after release. Some topics that are discussed in mediation are living arrangements, employment plans, time with children, communication, household contributions. And one memorable mediation included a mother and son who hadn't spoken to each other in 4 years. The son knew that he wanted to live with his mother after release, and the mother was in agreement, but there was tension around issues that happened during the son's childhood, in addition to the mother feeling afraid and nervous about his success after release, having not had contact with him in so many years. They both felt overwhelmed, not knowing what would happen after release. And through several mediation sessions, they were able to talk about what happened in the past, which turned out to be a huge misunderstanding, for which they were able to make amends and improve their communications. And they were able to make a detailed plan that included what transportation would look like, how they would find employment, what were each other's expectations while living together. And it was very powerful to witness and help them have this breakthrough in their relationship, and have a support system and plan for this individual, which increased his chances for success after he was released. So this case and many others like it is an example of how mediation is beneficial to those who are being released. And I support having this service available to everyone being released in Maryland. It can be used in many ways to talk about sometimes just clearing the air is important to people coming
Ms.
home.
Jones?
Okay, thank you.
All right, thank you very much. Christopher Dews for 2 minutes, please.
Thank you, members of the committee. My name is Christopher Dews, and I'm a policy advocate for the Job Opportunities Task Force, where our mission is to help lower wage workers advance to higher wage jobs. We support the Reentry Success Act, House Bill 1233, as a means of reducing barriers to employment for citizens returning from incarceration. And I would specifically like to address this from an employment access perspective. First and foremost, Maryland has an incarceration rate of 585 per 100,000 people. That's including prisons, jails, immigration detention, juvenile justice facilities. And of the 36,000 people, roughly 36,000 people that are currently behind bars, 18,000 are in state prisons, 11,000 in state and local jails, and 5,800 are in the federal system. So when these individuals return to society, they have to basically search for employment. And according to the National Employment Law Project, 1 in 3 U.S. adults have a criminal record that will surface in a routine background check. And it's estimated that 1.5 million residents, nearly 25% of the state's population, have a criminal record. The ability to secure stable employment is crucial to the successful reentry of individuals who have experienced incarceration. However, as you all know, a criminal record can serve as an insurmountable barrier to securing gainful employment and other critical resources, even if the record did not result in a conviction. Now, I'm saying all that to say this. We have a pre-apprenticeship construction training program at JOTF called Project Jumpstart, in which we work with Baltimore City residents to get them trained in either basically construction training in either plumbing, electrical, or carpentry. And we right then see the barriers to employment. The two biggest ones I want to address are three: transportation, criminal record, and just access to stable housing. We believe that this bill, House Bill 1233, will address just those specific issues right off the rip when somebody is returning, by returning their driver's license or ID to them and allowing them to be able to have access to resources and services, allowing 90 days of transit access through the bus tokens, which we see as a very powerful means of allowing people to be able to get to information sessions in different training programs, and set that up for them so that way they can jump towards getting themselves employed a lot sooner. It also will help them set up with food supplemental programs and make sure that they're well fed. These kind of things are critical. If they don't have these base level things, access to transportation.
Mr. Dews.
Wrapping it up right now, sir.
Please.
And access to transit, then they're going to be locked out of employment pretty much almost eternally. So for these reasons, we urge a favorable report. We hope that this bill will do great work to push Maryland residents back into employment who don't have.
Thank you very much. Abigail Thibodeau, please.
Hi, my name is Abby Tebow. I'm an assistant public defender at the Maryland Office of the Public Defender. I work in Charles and Calvert and St. Mary's counties. The Maryland Office of the Public Defender respectfully requests that the committee issue a favorable report on House Bill 1233. We believe it will aid in the successful transition of incarcerated individuals into society. As an attorney with the Office of the Public Defender, there are countless clients who come to our office who are there oftentimes for violations of probation, sometimes for subsequent accusations of crimes. And the reason they're there, it's easily identified as some kind of, as others have said, base need that was not met that led them to that point in their life. Particularly when it comes to violations of probation, we're seeing clients who could have met the qualifications or the requirements of their probation if they just had access to transportation, if they had the base things they need to survive, they had access to food. So I really like the provision about food stamps in here. Transportation, huge, like Mr. Dews said. These tiny things can keep people from coming back into the criminal justice system, which on a practical level, it cuts costs, it lowers corrections costs, it lowers court costs, it lowers the state's attorney's office's costs, it lowers costs of funding the public defender's office. But more importantly, it's the right thing to do. If we're going to, as a society, put people in incarceration, then we need to make sure that they're assisted with a transition back into the community. Just very briefly, the Maryland Department of Public Safety and Correctional Services puts our 3-year recidivism rate at 40.5%. In Virginia, where it's my understanding there's a greater focus on reentry programming and treatment, they have a 3-year recidivism rate of 23.4%. So that's huge. So again, practically it's going to cut costs, but more importantly, we're going to be keeping people happier and healthier, which is good for our community. So we do urge a favorable report today. Thank you.
Thank you very much. All right, we'll go now to Leslie Overholzer, please.
Good afternoon, and thank you for the opportunity to testify in favor of House Bill 1233. My name is Leslie Overholzer. I'm the Deputy Director of Community Mediation Maryland, a nonprofit supporting 14 community mediation centers across the state. We developed the reentry mediation program in partnership with DPSCS and have been providing reentry mediation across the state for over 10 years. I want to explain what reentry mediation is and what it is not. Reentry mediation rebuilds relationships, provides an opportunity for an incarcerated individual to meet pre-release with family members or others to have open, honest, and often difficult dialogue to transition back to the community. They're able to make plans around housing, employment, and other very basic needs. Reentry mediation works. Research shows that just 1 2-hour session decreases the probability of recidivism by 10%, and each additional session another 7%. The correlation between reentry mediation and reducing recidivism is proven with rigorous research. What reentry mediation is not is victim offender mediation. CMM and DPSCF have robust screening processes to ensure that a victim is not contacted to mediate with their offender. This screening process is multi-level, beginning at intake, and goes through a rigorous review of victim offender records by DPSCS before approval is given to mediate. I would ask you to vote in favor of this important bill. Relationships matter and reentry mediation works. It is so important to make this program available to all inmates housed for longer than 1 year, to set them up for that successful transition back to the community. Thank you for your time.
Thank you. Ricky Mannon, please, for 2 minutes. Ricky Mannon?
Hello, can you hear me?
Yes.
My name is Ricky Mannon. I was a participant in mediation while incarcerated, and I'd just like to share my personal experience very briefly. Before mediation, I went for mediation between my support system when I was coming home from my mother and my sister. And before we had mediation, our relationship was kind of rocky as far as we didn't really listen much. I had been out on my own for a while, so they had a lot of fears and anxieties about what would, my release coming home to them be like. For our first mediation, our mediations went great. The sessions went great. And initially after after mediation was initially done, we were kind of still skeptical that it would work because we were like, worried a little bit. But from all the sessions that we had and the great mediators that we had, we were not only able to like get everything across that we weren't able to get across in a phone call or even a visit, like really dive into deep fears or deep worries or deep, goals that we had to touch down, and we were able to hold each other accountable because we had somebody that was there to listen to us and pretty much put our stuff out there for us to work on. We had action items, and it really held us accountable. It helped out a lot. Moving forward afterwards, our relationship between my relationship between my mother and my sisters have greatly been impacted because not only have we learned about from mediation how to listen better and communicate a lot better. Like I said, we've held each other accountable. We've even had conversations like, what would our mediator say if she saw us, getting like this? And it's really helped out with a lot of listening skills, communication skills for me, both professionally and personally. And I've been home for 4 years. I haven't had any trouble with the law at all. And I can definitely say mediation had a great impact on helping me with communicating and getting my support system ready for, and me being ready for my support system when I came home. We were able to discuss all those things in detail without, getting cut off from a phone or everything. We really had enough time to deal with it. So it was very helpful. Thank you for allowing me to testify, and God bless you all.
Thank you very much. All right, the state's attorney for Howard County, Rich Gibson.
Good afternoon, everyone. Thank you for giving me the opportunity to speak. My name is Rich Gibson, state's attorney for Howard County. I've been a 17-year prosecutor, and I'm currently the president of the Maryland State's Attorney Association. In our line of work, we get no enjoyment. We're one of the few industries we get no enjoyment out of seeing returning customers. It's our hope that when we interact with someone, that the result of that interaction is transformative, and that after that, the individual pays whatever debt they do to society for the wrong they've committed. They can move forward with their life and avoid any future criminal activity, becoming a contributing member of our society. I'm testifying today in support of House Bill 1233 with the amendments that Delegate Feldmark mentioned. I think it's a solid effort in addressing some of the stumbling blocks that exist for people reentering society after a period of incarceration. They, of course, face challenges like obtaining proof of identification, transportation, so they can find employment, having medical supplies, so they can address their medical or health issues upon release. And while we support this bill, the crucial amendment that Delegate Feldmark mentions is essential for us, and I strongly urge the codification of protections in Section 1A of the bill. Section 1A of the bill as it currently is drafted reads that the Department of Corrections would provide private mediation between the inmate and the person of the inmate's choosing. That language, as it's currently structured, is too broad. So we can't allow our desire to see successful reintegration in our society to be used as a tool to engage in psychological warfare against victims or witnesses. Therefore, we need to put in place specific provisions of the bill that will protect individuals that have been previously victimized by the inmate, people who've been witnesses in cases where there's no contact orders, things of that nature need to be put in place to protect them. But the underlying premise of the bill, we strongly support, and I urge a favorable report for House Bill 1233. Be glad to answer any questions. Thank you.
All right, we'll go to questions now. Delegate Bartlett.
Thank you, Mr. Chair. I have two questions. My first question is for Mr. Christopher Dews. I appreciate Ms. DeBolt's testimony in which she mentioned the net effect of lowering cost, but what is the benefit to the state revenue when a returning citizen is able to secure employment? This is for Mr. Dews.
Yeah, so there's tremendous benefits, of course, directly with revenue. So of course, if an individual now who is currently doesn't have access to employment, has access to employment, then that, of course, net, of course, will end up with tax revenues going back to the state. I believe, for example, we know with the Earn Grant funding, the Earn Grant program, which is the Employment Advancement Right Now Act, $1 into funding for that ends up with $17 coming back to the state. So, and that's just that's just a job training program to get people employment opportunities. And so when a person, I guess I want to say just two things. If a person now has full-time employment, specifically, we see this with our training program as well. If they are now working a job for $15, $20 an hour in construction, tax money is being taken out, children are now being taken care of. And so I guess to say that that social services are now lessened. So that burden is also lessened on the state. And so, yeah, I mean, I hope that answered the question, but
it does. It answers my question. Also, my next question is for Ms. Overholster. And you mentioned, and shockingly, you mentioned the comparison with Virginia, 40.5% recidivism rate in Maryland versus 23.4% in Virginia that has programs assuming similar to what is being proposed in HB 1233. Can you talk, if you have that information, can you speak to some of the programs that Virginia offers, if you have that?
I don't actually have access to exactly what those programs are, just the statistics that they have a lower recidivism rate and that they have reentry programs in place. So
I'm sorry. Thank you for answering.
I was the one who cited that. So.
Oh, you were? Oh, okay.
Yes. So that's why I kind of jumped in there.
Okay.
And,
all right. Thank you. I was so busy taking notes. I didn't see. Okay.
That's
so
okay.
That's okay. That's fine. Thank you very much. Thank you, Mr. Chair.
Thank you. Delegate Rachel Jones, please.
Good afternoon. I want to thank Delegate Feldmar for bringing this bill. I think this is definitely something that's needful. I have a couple of questions. So I know Mr. Dews mentioned, the passes for public transportation and some of the access issues with workforce development and employment. One of my questions, and I guess this is kind of for the bill sponsor as well, but the bill mentions, the transportation passes, but there's lack of access to transportation in some of the rural parts of Maryland, where, we don't have a major mass transit system in Southern Maryland particularly. And so what options are there, for folks who are returning from incarceration in rural areas?
Yeah, thank you for that question. I do think that is a shortcoming of our transportation system in general. The objective here with this provision in the bill is to make sure folks can take advantage of the systems that are available. Unfortunately, it doesn't help where those systems don't exist. And so if you have creative thoughts for, alternatives for areas that aren't served by transit, I am happy to have that conversation. So it's really just sort of focused on making sure that where the transportation or transit infrastructure was there, that returning individuals would have access to it.
If I may, to Delegate Rachel, as someone who was incarcerated in the rural area, I know that some institutions offer transportation back into kind of the main parts of the district. And so maybe it's an opportunity to reach out to the local jails in your district. And I'm open to helping you do that, where we can find out what resources the county jails that are in your district have available that offers transportation back into some of the areas that they know people live in. Because I was incarcerated in Hagerstown, and at that time, they had a bus that would get you back into the main part of the city. I don't know if this bill addresses that, but I totally understand where you're coming from, and I think that's kind of a targeted question to the institution in which where the county, where the jail is, where you represent, a conversation with that warden to find out what resources already exist in terms of transportation that institution could, support or even apply for additional funding to provide.
Okay, thank you. And Delegate Feldmark, I will, follow up with you if I can propose any amendments that might make this more suitable for folks in rural areas as well. And then,
thank you.
You're welcome. And so, Mr. Dews, you mentioned, again, you brought up some really pertinent issues. Would you talk about or explain a little bit how, the $50 that, an inmate gets upon their release? I mean, how far does that actually go? Because in my experience with the reentry folks that I've worked with, it doesn't go very far. Would you just speak to that a little bit?
Yeah, I can speak to that rather quickly. As you already said, it doesn't go very far at all. I mean, just imagine if you were applying for opportunities and you had 5 job offers, not offers, but 5 interview opportunities, and you had to catch a bus. If you're in Baltimore City, for example, I believe the daily bus route is $5. So you can maybe get to 10. I mean, if you don't spend on anything else, $50 is just generally not enough. And to your question about transit, generally speaking, even in the Baltimore region, public transportation can only get you to 9% of the jobs that are out there. So generally speaking, the transportation systems are lacking. $50 is of course not enough, and that's the reason why we're supporting this bill. We think it's going to do at least take the step forward and trying to end a lot of these inequities, because it is way too hard, as another testifier already said. Reentry is already way too difficult. So that's the best I can answer that question.
Okay. Thank you.
Thank you.
Delegate Cham.
Thank you, Chairman, and to committee members. I just had a question for point of clarity regarding the transportation piece in the bill. Are Ubers and cabs and taxis considered public transportations, or are we just talking about mass transit buses and metro systems?
Well, I can say as drafted, the focus really was on transit systems, although in response to Delegate Jones's question, it did get me thinking about in rural areas what what the possibilities may be for those kinds of services.
Okay, thank you.
Thanks.
And that's also a corrections question too. And that would, it's my hope that the committee members would begin to dab a little bit into the Department of Corrections budget when they go up in front of your colleagues in appropriations, because it is also on them to allocate appropriate funding for their constituency. So, I think you all are bringing up valid points that oftentimes don't come up when corrections are in front of many of the committees. And these are the type of questions that we should be asking of the Department of Corrections in the local jails.
Thank you very much. Seeing no further questions for the panel in favor, we thank you all very much for speaking to us, and we'll hear from those in opposition. Melanie Shapiro and Lisa Jordan now. we could have them brought in, please. We'll hear from them for 2 minutes. All right, I see Lisa Jordan, so we'll go ahead and start with Lisa Jordan for 2 minutes, please.
Thank you, Mr. Chairman, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We really reluctantly must oppose House Bill 1233 as it is written. We very much appreciate Delegate Feldmark and her willingness to work with us regarding amendments. But as introduced, the bill presents significant safety concerns. It lacks the mandated protections for survivors of sexual violence and other crimes against the person. So we're looking forward to the amendments, but as it stands, we request an unfavorable report. As you've already heard, permitting an inmate to choose who would be invited to the mediation and who would be essential for their successful reentry is something that really could easily be abused to manipulate survivors, to manipulate witnesses. And we know a lot about kind of mediation and screening from the family law context. And I can tell you that we heard over and over again that the courts would screen for violence, that they would protect survivors. And we found that the screening tools were often inadequate. And these are volunteer mediators, and they often just have an unrealistic view of how they're going to be able to assess the situation. The screening that we learned about is really questions about, do you feel uncomfortable? But if you're already intimidated, you're not always going to talk about whether or not you feel uncomfortable. And these mediators, the volunteer mediators, are not people who are known to survivors. We also note that the crime victims' rights system is underutilized in Maryland, that stay away orders often do not extend to friends and families and neighbors and people around a survivor. And also want to say that the procedures really need to include screening for power-based personal violence, in general. All of that aside, we absolutely are committed to working with the proponents to find a solution for these issues. I note that 86% of women who have spent time in jail report that they have been sexually assaulted at some point in their lives. So this is very much something that we believe should be worked out, should have a strong program in Maryland. And certainly the provisions regarding basic necessities listed on page 2, lines 23 through page 3 on line 8 are crucial. I also just want to acknowledge and appreciate Ms. Holzer, Ms. Peter Jones, and say that we wish to continue to work together, but as it stands, we request an unfavorable report on House Bill 1233.
Thank you very much. Melanie Shapiro now for 2 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence, the State Domestic Violence Coalition. And we too must reluctantly oppose HB 1233. To be clear, we fully support the reentry efforts that are found in the bill, starting on page 2, lines 23 until the end of the bill. Those that would assist with transportation and licenses and insurance and all of those additional things. Looking at the fiscal note, the 19 social workers, I think, are more than necessary to ensure the successful return of citizens to their homes and communities, and we fully support that. Our concern is surrounding the mediation. We've talked specifically about what the language entails and power-based violence. I would note that this bill specifically refers to mediation and not restorative justice as a whole. Mediation is grounded in the belief that the parties are equal footing and morally the same, whereas in restorative justice, it recognizes a power imbalance and that one person has been wronged by the other and must be restored. And so I would like to have further conversation about whether it should specifically be mediation or restorative justice as a whole, as well as ensuring that there's proper training and screening. Domestic violence is one of the most underreported crimes. So limiting the reach to individuals who have been identified as a victim, who have had a protective order. We know that there are tens of thousands of individuals a year who are victims of domestic violence that goes unreported. And so we don't feel that that should be the baseline to be used, that it needs to have sufficient screening and sufficient training for the mediators to in fact be able to identify this power based personal violence that may have occurred, and that individual is not the one who is involved in any type of mediation. So for all of those reasons, and I did want to thank Delegate Feldmark. She did make an effort to bring all of us together. Unfortunately, with the time constraints of session and having to file testimony Friday for today's hearing, we were not able to come to a meeting of the minds. We very much look forward to working with others to see if there is some language that we can agree to. But at this time, we have not been able to find that. So we are opposed to the bill. Thank you.
Thank you very much. Delegate Juanita Fisher, please.
I'm okay, Mr. Chair. They answered my question in their testimony about why there wasn't an amendment.
Thank you very much. Any further questions for this panel? All right, seeing none, we thank you very much. That concludes the testimony for House Bill 1233. We are now going to go to House Bill 1269, Delegate Juanita Fisher. We'll hear from Delegate Fisher, then go to Kim Haven, Stanford Frazier, Mary Denise Davis. In favor of the legislation, we'll hear from Delegate Juanita Fisher now for 3 minutes. Go ahead.
Thank you, Mr. Chair. I wanted to say this might be my last bill in front of the committee, but I'm actually not sure, so I'm not going to say that. For the record, my name is Delegate Juanita Fisher. I represent Prince George's County, and it's my pleasure to introduce House Bill 1269, which addresses the waiting period on the expungement of records. The goal of this bill is to allow people in Maryland to have a fresh start and to shorten the time period from 3 years to 18 months in order to get an eligible record expunged. This will allow the petition for a specific waiver and release form for certain circumstances. Speeding up this process will allow civilians better access to resources and opportunities when it comes to employment and moving on with their lives. Something that this committee knows of me. I'm a big believer in, taking responsibility from your actions, but once that responsibility is taken, I believe that Marylanders deserve the opportunity to be fully back in our fold of society, and also have the opportunity for opportunities such as jobs and education. You'll hear from my esteemed panel, and I hope that this committee will vote in favor of HB 1269, and I look forward to answering any specific questions. Thank you so much, Mr. Chair and committee.
Thank you very much. We'll go now to Kim Haven for 2 minutes, please.
Mr. Chair, I think Kim texted me that she had another hearing conflict. If she doesn't make it back, I think she submitted written, or she will to the committee.
I think I see Stanford Frazier, so we'll go with him.
Thank you, Chair. I'm Stanford Frazier with the Public Defender's Office, and the Public Defender's Office is asking for a favorable report on this bill. Public defenders, we often hold expungement clinics for our clients, and we know firsthand how criminal convictions may prevent clients from obtaining housing, employment, and certain professional licenses. We believe that changing this law and decreasing the waiting period will be able to will help our clients and be able to help Marylanders suffering from collateral consequences. And for those reasons, we urge a favorable report on this bill.
All right. Don't see Mary Denise Davis here either, so we will stop right there and ask if there are questions for Delegate Fisher or Mr. Frazier. Delegate Cox.
Thank you, Mr. Chair. Thank you, Delegate Fisher. And I don't know who would be best to answer this, but what about the judiciary's point that the 3-year statute of limitations is the reason for this? And is it possible to look at an amendment for that, or what's being done regarding the judiciary's position on this?
I would be open to, I'm sorry, Mr. Frazier. I'd be open, Delegate Cox, to work out any technical issue that the committee or the subcommittee would deem appropriate. So I would be open to trying to rectify their concerns the best way we could. So.
Are there further questions? Seeing none, that concludes the testimony for the panel. We'll go to one in opposition, John Cox. John Cox for 2 minutes. He's connecting. Mr. Cox? Mr. Cox?
I'm sorry, Chair Clippinger. I was trying to figure out when I was in, and I appreciate.
All right, you're fine. If you could turn on your video, I'd appreciate it.
Very.
There we go. Off you go.
Very sorry. Inexperienced this year, I guess. Chair Clippinger, Vice Chair Atterbury, members of the Judiciary Committee. I'm John Cox. I'm Deputy State's Attorney in Baltimore County. And speaking on behalf of the Maryland State's Attorneys Association, we are opposed to House Bill 1269. As is obvious by the bill itself, it basically takes almost all the categories of dispositions in 10-105 of criminal procedure and changes the waiting period from 3 years to 18 months. We are opposed in almost all of those categories. First, as to probations before judgment, it's our position that, and I agree with Delegate Fisher, that we want to have people prove themselves back and get back into society. 18 months is just too short a period for them to demonstrate that. If they get a probation before judgment, let's say for a shoplifting, get it expunged within 18 months, and then go out and commit that same offense the next day, we end up in a cycle where that will can continue if the individual chooses to continue to commit other offenses, and the judge would know nothing of the prior ones. With regard to the stet, it is at least the common practice, I believe, everywhere in the state that stets are open basically for 3 years. Say, for example, in a domestic violence situation, if you have a condition of a stet that they have no contact with the victim and or get domestic violence counseling, if you expunge that after 18 months, then you've lost half the time period in which we're trying to enforce those conditions and assure the safety of a victim. As was Delegate Cox mentioned, the concern about the null pros stets and acquittals is about the statute of limitations for any civil proceeding. Right now, a person can get a null pros, a stet, or a null pros, an acquittal or a dismissal expunged right away, as long as they sign a waiver of release and a release from any civil action. The 3-year time period is there logically because there's a 3-year statute of limitations. If they choose not to sign a release, then the person who may be sued, let's say 19 months later, ought to be able to defend themselves. They're not going to have that opportunity if, in fact, basically everything's been taken out of the record. I use an example sometimes. Let's say somebody commits a shoplift, the police respond, and on body cam they confess to it. Then it goes to court, and unfortunately, the store detective who saw this whole thing happen has left the state. So the
Mr.
case
Cox,
the
wrap up.
Thank you. The State's Attorneys Association opposes and asks for an unfavorable report.
All right, thank you very much. Are there questions for Mr. Cox? All right, seeing none, we thank you very much for your testimony today. And that concludes the testimony on House Bill 1269.
Thank you, Mr. Chair. And I'd like to report this is my last judiciary bill for the year. So thank you, the committee, for all of the indulgence.
Thank you very much. House Bill 1227 is next. Delegate Rosenberg is here. We're going to hear from Delegate Rosenberg for 3 minutes, then Meredith Wiesel and Matt Peterson. They're each going to get 2 minutes. Then we will have testimony in opposition. So Delegate Rosenberg, go ahead for 3 minutes, please.
Thank you, Mr. Chairman. Domestic terrorism, as this committee well knows, is a major threat to our personal well-being, as well as to the well-being and maintenance of our democratic system. We all know the events of 2 months ago. We're all familiar with what happened in Michigan, what didn't happen in Michigan because the FBI intervened. This is not the first time I've come before the committee with legislation to try and address this problem. This year's bill would create a task force. Officials from a broad array, legislature, executive branch, law enforcement, civil rights community, to see what is the best way Maryland should try to deter these acts, because it is far better to deter them than to indict afterwards and after the damage has been done. Make the point of saying that this bill is a task force because last year I introduced legislation creating a statutory crime. In effect, treating domestic terrorism like we do a hate crime, imposing a, if found guilty, an additional penalty, an enhanced penalty for a felonious act that was also domestic terrorism. The committee did not take action on that bill formally, but May 11th of last year, Mr. Chairman, you were kind enough to send a letter to the Honorable Walter F. Pete Landon, Director of the Governor's Office of Homeland Security, asking him to report on the state's efforts and plans to prevent, detect, and address domestic terrorism to the extent that the publication of such information does not jeopardize public safety or security. I've spoken with committee staff today. No response has been received to this letter. Therefore, I think it is imperative that we take legislative action to make sure that we do study this issue. I know that there is opposition, and my understanding, I haven't seen the testimony, but my understanding is, well, that if we have a domestic terrorism task force or subsequently an arm of the state police that deals with terrorism, it will abuse that authority. Well, that's why we are here to, when we have a challenge of that nature as a legislature, if there is a significant problem before us, we have to address the problem as broadly and as importantly as the problem before us. That is, if the committee believes ultimately that there should be a statutory crime, then we also, it is imperative that we provide that appropriate guardrails for enforcement and prevention so that it does not lead to abuse. I urge a favorable report. Thank you.
Thank you. Thank you very much. We'll go to Meredith Wiesel, please, for 2 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. I believe this might be the last bill I'm testifying on this session before this committee. So with that, again, Meredith Wiesel with the Anti-Defamation League, we're here to support House Bill 1227 and thank Delegate Rosenberg for introducing it. ADL, just as some background, for decades, one of the most important things that we have worked on is, of course, we've talked about fighting bigotry and anti-Semitism, but it's also been investigating extremist threats across the entire ideological spectrum, in particular, white supremacists, and looking at the far-right violent extremists that we've seen. We produce a lot of research and intelligence briefings to inform the public on the scope of this threat that we've seen. We've said time and time again that extremists have to be taken at their word, and that sometimes volatile rhetoric can bleed into calls for violence. The online rhetoric we see bleeds to explicit violence, particularly what we saw happen on January 6th at the Capitol. The cycle didn't begin though on January 6th. It's been part of an escalating pattern that we've continued to see, so that's why the first step we need to do is to acknowledge the nature and magnitude of the problem, which is what is happening here, and then find ways for the federal and state governments to embrace the need for new approaches. It's important to remember that white supremacy has experienced a resurgence. It's been driven in large part by the rise of the alt-right. That's what we consider the newest segment of white supremacy. It's mostly youth-oriented. It's been overwhelmingly male, and they've produced more energy to the movement. Violence and crime also represents one of the most serious problems that we've seen emanating. Murders and terror plots represent just the tip of the iceberg. And from 2016 to 2019, white supremacists alone killed 116 people in the United States. They committed terrorist attacks, hate crimes, and other violent acts. It's unfortunate we can't always legislate and regulate and arrest our way to a healthy and more accepting society, but we know that the fundamental cause of bias-motivated violence in the United States is persistent racism, anti-Muslim bigotry, anti-LGBTQ bias, anti-Semitism, all forms of identity-based hate.
So,
yep. I will wrap up, I promise. So with that, I've provided for you in my testimony a packet called the Protect Plan. And one of the things that we note is that it's important to start a task force. The other thing, just to wrap up, is it's important that civil rights organizations are included as part of it. Thank you.
Thank you very much. Matt Peterson, please, for 2 minutes.
Thank you. Thank you, Chairman Clippinger, Vice Chair Atterbury, members of the Judiciary Committee. My name is Matt Peterson on behalf of the Baltimore Jewish Council in support of HB 1227. What we saw on January 6th in Washington, D.C. Was only a symptom of a much larger and more complex problem that our country is facing, and that is the rise of domestic terrorism, the rise of hate groups, and the fact that it's becoming a phenomenon that's harder to track, that is moving to new digital platforms that are emerging and much more difficult to follow. So we need to make sure that however we address this issue, it is something that is targeted, that is only going to be used in the correct way to go after the problem that we're facing, which is domestic terrorism, but also hate. At the Jewish Council, we always say that the best way to address hate is through education, to treat it early before it bubbles over into something like we've seen at the Capitol, in Michigan, and other situations. So we want to figure out that however we do that, we're doing it correctly and in an effective way that's using state resources in the most effective way possible. The Jewish community has been targeted for many years, for decades, with mass shootings like we've seen at the Tree of Life Synagogue in Pittsburgh and other unfortunate incidents since. And we at the Baltimore Jewish Council support the state taking action to address this problem. And with that, I want to thank you for your time and urge a favorable report on House Bill 1227, and I'm happy to take any questions. Thank you.
Thank you very much. So questions now for the panel, starting with Delegates Grammer, then Griffith.
Thank you, Mr. Chair. Delegate, thanks for being here today and presenting the bill. Can you tell me how you define terrorism in the bill?
Well, that would ultimately be a decision for the, first for the task force and then for this body, if we were to make it a crime.
How would you define it under your perspective on this bill?
Well, in this instance, it would be acts directed at the operation of the government. They are prompted by animus towards the government, and that would prevent government action, lawful government action, from taking place.
So the Webster's definition is close to this: the unlawful use of violence and intimidation, especially against civilians, in the pursuit of political aims. Would you generally agree with that?
Yes.
Okay. Can you give me some examples over the last year of what kind of behaviors you're looking to tackle here?
Well, I would quote the director of the FBI, which is in my testimony, if I can find it, when he testified, he said that attack, referring to the attack on the Capitol on January 6th, that siege was criminal behavior, plain and simple, and it was behavior that we, the FBI, view as domestic terrorism. It's got no place in our democracy. I concur with that statement.
Clearly, but any other, in some of these other states, there were activities led by Antifa. They take over physical spaces. Would that be covered under the bill?
That would be a question for the drafters for us ultimately to decide, but I think all evidence is clear overwhelmingly. The acts of domestic terrorism have been overwhelmingly perpetrated not by Antifa, but by other groups.
The reason I ask is, so after 9/11, there was the call for action against domestic terrorism, and it tended to be used more towards political groups. There were anti-war groups that were labeled as domestic terrorist organizations. There were civil libertarian groups that were labeled as domestic terrorists, and many of the members of those groups were actually arrested. And this new anti-domestic terrorism movement is moving forward, it's not necessarily about an equal, it doesn't seem to be aimed at an equal, aimed at public safety as a response to domestic terrorism. It seems very much to have a political flavor to it. And I'm really concerned about that. Some of the examples we've talked about this year, specifically Duncan Lemp, he was killed in a no-knock warrant, and the warrant was found to be bust. And in retrospect, they labeled him as a domestic terrorist. So I do have some concerns, but I'll be happy to take a peek through the bill, and I appreciate your answers.
If I may, Mr. Chairman.
And
the delegate expresses a valid concern. I raised that, or at least tried to address it in my testimony, saying that we need to have guardrails, look at past experience, to ensure that those guardrails are as sound as we can make them. But nothing is perfect.
Thank you.
Delegate Griffith, please.
Thank you, Mr. Chair, and thank you, Delegate, for bringing this bill. I remember last year, the version that was presented last year, I think if I remember correctly, one of the concerns that we unpacked, that I think you and I unpacked, was that the peaceful protesters blocking I-83 following during the Freddie Gray uprising would have been impacted by that bill. So I appreciate the task force, but I have two questions, one for you and one for other panelists. And as a response to something you just said, I mean, we clearly reject white supremacy, and we clearly reject, people, unlawfully entering the Capitol on January 6th. I don't think there's any room for that, period. But one thing you kind of brushed aside was the fact that Portland, Oregon has been under siege by Antifa for 150 days. I think would those type of acts be affected, and would those people be violating the law under this bill?
Well, under this bill, there's no definition of terrorism. So if the task force, if the bill passes and the task force recommends a definition of terrorism, and this committee and then the full legislature were to adopt that recommendation or modify it, any individual, regardless of ideology, as the committee well knows, regardless of ideology or skin color, religion, would be affected. Subject, I would hope, by the guardrails in terms of, there wouldn't be guardrails on indictments. That would be, we established the guardrails on indictments with the definition, the language in the bill. But in terms of police prevent police activity, surveillance, and so on, that we would hopefully have adequate guardrails so that there isn't abuse.
Well, thank you for that. And I think we all stand together rejecting, terrorism and hate in all its forms. And one last question for Mrs. Mrs. Weishold. Am I saying that right or wrong?
Weisel, you're good.
Weisel, all right, good.
Meredith, though, not Mrs. Please.
Meredith, I appreciate that. I'm still worried with the whole delegate thing, trying to get comfortable with that. So would any acts by the BDS movement under this bill, would you support members of the BDS movement who commit terrorist acts be held accountable under this bill as well?
Under the BDS movement? Is that what you said?
Yes.
Well, so let me be clear about a couple of things. This is to create a task force, and the task force's job would be to define what domestic terrorism means.
Sure.
So this is part of establishing it. So whether or not something like that would be captured in this or not is very hard to say. What I want to just sort of point out is, and I think this goes to Delegate Grammer's question too, terrorism, and specifically when we're talking about terrorism, you're talking about a pre-planned act or an attempted act of significant violence. And it can be because of ideological or social or religious cause. And it's when they're trying to harm a perceived opponent. And when we're talking about domestic terrorism specifically on creating a task force like this or putting in statute, you're talking about violent acts of mass destruction, anything from assassinations to targeted killings to arsons, fire bombings. I could go on and on or whatever. So we're talking about attempted acts by the perpetrators who are resident citizens of the country here. So whether or not something like BDS would be captured, I mean, it depends on how they're acting. In the moment, if they're coming in and they're storming the Capitol also, let's just say that, then it's quite possible they could be captured. But that's part of why it's important for the task force to also include people from civil rights organizations. We also noted in our testimony things from like the public defender's office and law enforcement, so that you have that balance to understand, so that actors who are peacefully protesting are not being captured in this statute. We're talking about violent extremism, which is why we focus so much on white supremacy in particular, because that has been the most violent acts that we have seen, more than 75%. So again, I can't answer whether BDS would specifically be captured, because I just don't think, it depends on the individual protesting on behalf of that, and if it's a peaceful or if it has become some sort of destructive violence.
Absolutely. I just want to make sure, that the testimony was very focused on one set of groups who are perpetuating terrible, terrible crimes. I just want to make sure that we're focused on all violent acts of all ideologies here, not just one-sided. Thank you.
Yeah, no, understood. Again, I think the biggest thing is that we just need to know when we're talking about violent extremism, which is most of what we're talking about with domestic terrorism, has been focused more coming from white supremacists or right-wing extremists. On the other side, there hasn't been as much violent acts. So that's part of why the focus has been that way and what we've seen over the past few years.
Are there further questions for the panel? Seeing none, we thank you very much. We'll now go to the person testifying in opposition, Seth Grimes. Mr. Grimes, you have 2 minutes. Mr. Grimes?
Sorry, yes.
Yes, you need to, there you go, for 2 minutes, please.
Thank you. Chair Clippinger and members of the committee, my name is Seth Grimes. I'm representing Tacoma Park Mobilization, which is an advocacy organization with a network of over 2,600. Tacoma Park Mobilization opposes HB 1227. We oppose the statute. The optics, while we recognize the good faith of Delegate Rosenberg, the optics suggest that this is not a bill to proceed with. It has chilling implications for Maryland immigrants and people of color. It devotes 5 whereas clauses to insisting to promote inclusiveness, celebrate diversity, work to ensure equitable opportunities, and reject hate and bias. Why did the sponsors include this protestation? Because they understand that the efforts of this sort often mistarget marginalized and dissenting neighbors rather than white supremacists. For instance, I bet you anti-immigrant elements would seek to add MS-13 to the task force agenda. Our own experience here in Maryland suggests that if HB 1227, if enacted, would be mistargeted. I quote a 2008 article. Maryland officials now concede that state police wrongly listed at least 53 Americans as terrorists in a criminal intelligence database and shared some information about them with half a dozen state and federal agencies, including the National Security Agency. Those surveyed by the Maryland State Police included then Maryland Senator Jamie Raskin, who was guilty only of meeting with constituents whom the Maryland State Police deemed suspect. Further, HB 1227 is unneeded. It's premised on issues encountered elsewhere. In Michigan, as you've heard from the other witnesses, where heavily armed white supremacist militias run rampant. That's not Maryland. And at the US Capitol, they provided no evidence of a need here in Maryland. This bill is redundant, adding nothing to the current toolkit for countering domestic terrorism. And I'll note that Delegate Rosenberg's definition, there is no definition in this bill, so the task force could take this anywhere. The mandate is problematic. I'm quoting, what practices for countering domestic terrorism could there be other than more police and more militarized police? The direction to provide oversight measures.
Mr. Grimes, if you would please.
Thank you. I will wrap up by reiterating that Tacoma Park Mobilization urges the Judiciary Committee to reject HB 1227. Thank you.
Are there questions for Mr. Grimes? Seeing none, we thank you all very much. And that concludes the testimony on House Bill 1227. Now on our last bill of the day, House Bill 1331. This is Delegate Deborah Davis's bill. We'll begin with Delegate Davis for 3 minutes, and then Corey Johnson, Priya Jones, Nicole Hanson-Mundell, and Stanford Frazier. After that, we'll take the remaining people signed up to testify, either favorable or favorable with amendments. Delegate Davis, if you would please, for 3 minutes.
Good afternoon, Mr. Chair, Madam Vice Chair, and colleagues of Judiciary. For the record, my name is Deborah Davis from District 28 in Charles County. I'm here to present HB 1331. It's entitled Maryland Criminal Justice Debt Elimination and Prevention Act of 2021. And I ask for a favorable report. Over and over in our committee, we hear testimonies from citizens giving examples of how disproportionately oppressive fines and fees and punishment can be. Congress abolished debtors' prisons in 1833. Our United States Supreme Court declared debtors' prisons unconstitutional just 150 years later. But yet we still manage to incarcerate poor people for debt, and we even fines and fees. We even create an underclass of citizens for debt. I present to you a bold solution and submit that it's time that we seriously consider the decriminalization of poverty, recognizing that excessive and duplicative fines and fees pose serious hardships to average working families and create barriers to success. Thank you, and I ask for a favorable report.
All right, we'll go now to Corey Johnson from JOTF, please, for 2 minutes.
Good afternoon, Mr. Chair, members of the House Judiciary Committee. For the record, my name is Corey Johnson, and I'm an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force. I would like to thank Delegate Davis for her timely introduction of House Bill 1331, as now more than ever, protecting the interests of our most vulnerable populations is extremely important. The Fifth Amendment, incorporated through the 14th Amendment, requires that no person should be deprived of life, liberty, or property without due process of the law. Yet 36,000 Marylanders a year are plagued with thousands of dollars in fines and fees, many of whom have never even been convicted of a crime. These fees include GPS monitoring, pretrial room and board fees, work release, parole and probation fees, vehicle interlock devices fees, and the like. This has led to a parasitic cycle of exploitation whereby the state places the financial burdens on citizens to fuel the fiscal agenda of the Corrections Department, functionally criminalizing poverty. This has also consequently led to a criminalization of race. I would like to remind the committee that the Vera Justice Institute reported that Maryland leads all other US states with the criminalization of Blacks. Despite Black Marylanders only making up 30% of the population, 70% of our prison population is Black. This suggests the impacts of fines and fees are most felt by racialized minorities and those falling beneath the poverty line. To use the city of Ferguson as an example, in 2015, the DOJ reported that the revenue generated from the collection of criminal justice fines and fees made up $3.9 million out of a total of $11.7 million in general revenue funds. The practice of funding an entire city on the backs of individuals that have never been convicted of a crime is not only morally bankrupt, but unconstitutional. In Nelson v. Colorado, the Supreme Court held in favor of an individual who was forced to pay exuberant fees despite being found innocent. In her majority opinion in 2017, penned by late Justice Ginsburg, she indicated that per a due process right, an individual maintains a presumption of innocence, and as such, requiring fines and fees is unconstitutional. House Bill 1331 seeks to eliminate fines and fees that are associated with an individual's interactions with the criminal justice system. The state of Illinois just became the first state to completely eliminate all criminal justice fines and fees and are 100% financed by the state. We are hoping that the state of Maryland can do the same. For the reasons above, we urge a favorable report of House Bill 1331.
Priya Jones, please, for 2 minutes.
Hi, good afternoon, everyone. Thank you to the members of the committee for allowing me to testify today.
in support of Maryland's House Bill 1331. My name is Priya Sarthi Jones. I'm the National Policy and Campaigns Director at the Fines and Fees Justice Center. The Fines and Fees Justice Center is a national hub for information, advocacy, and collaboration for reform on fines and fees. We seek to end the use of fees in the criminal justice system and administer fines in a more equitable way. The use of fees in the criminal justice system is a form of regressive taxation. Rather than paying for our criminal justice system through general funds and budgets that support the needs of the system, we overuse that system and charge those costs to those who are unfortunate enough to have contact with it. Oftentimes, these are brown and Black residents in low-income communities that bear the burden of the structure. A movement to end fees in the criminal justice system is starting to take hold in this country. There are many examples of jurisdictions ending certain types of fees, and just this past summer, California ended charging 23 of its most egregious fees in the criminal justice system. New York has recently launched a campaign to do something similar and end various fees and surcharges. Maryland understood the importance of this issue and ended the practice in the juvenile system just last year. Maryland passed the most comprehensive juvenile fee and fine repeal that has been passed anywhere in the country. While other states have also dealt with fines and fees for juveniles, Maryland went a step further, forgiving all outstanding fines and fees. HB 1331 is a great bill that seeks to make the criminal justice system more equitable and less disproportionately punitive on those who can carry the cost the least. Passing this bill would make Maryland a leader once again, setting an example to other states that there is a better and more just and fair way to administer our criminal legal system. A system that benefits society should be carried by all of society, not just those who find themselves part of that system. This is a principle that we apply to other essential aspects of our society, such as education. When the government deems it necessary, then the government and all the people must be responsible for it collectively. Ending these fees and establishing a better and more reliable funding structure is our path forward. I encourage this committee to pass this bill. It will make a huge impact in the lives of Maryland residents and keep Maryland moving in the right direction. Thank you for the opportunity to address this bill and for the Fines and Fees Justice Center to express its support.
Thank you very much. We'll go now to Stanford Frazier, please, for 2 minutes.
Good afternoon. I'd like to thank the chair and the committee for the opportunity to testify today. My name is Stanford Frazier, and I'm with the Government Affairs Division of the Public Defender's Office, as well as a trial attorney in Prince George's County. This legislation we urge a federal report of this bill, my apologies. This legislation to eliminate many fines and fees directly impacts our clients and their ability to lead productive lives. There are many components of this bill, so I want to focus my limited oral testimony on some of the pretrial detention fees addressed by the bill. In recent months across Maryland, our office has represented numerous individuals that have been struggling to pay expensive private home detention fees. And in some cases, we've had clients that have been released for 3, 4, 5, 6 months that have then been forced to become incarcerated at the jail simply because they could no longer afford these expensive fees. These are individuals that were successful on pretrial release. There were no violations, and courts deemed that they were not a danger to a community nor a flight risk. But because they could not pay the indefinite amount of fees necessary while you're waiting for a trial date that continually got pushed back, they were forced to then become once again caged. These kind of stories from our clients is just one example of why the Maryland legislature should eliminate the fines and fees associated with pretrial proceedings and the criminal legal system overall. And for those reasons, we urge a favorable report on this bill.
Okay. I was giving Nicole Hanson-Mundell an extra second to get on board here, but it doesn't look like she is coming back on, so we'll take questions now. We'll go to Delegate Griffith and then Delegate Bartlett. Delegate Griffith.
Thank you, Mr. Chair, and thank you, Delegate Davis, for bringing this forward. To help me understand the bill, so this would eliminate all fines and fees, or just for those that are acquitted, and would people that are convicted have to go back and pay those fines and fees?
So there, in answer to your question, Delegate, there is, it's outlined in the fiscal note, but it is a myriad of all those things. It reduces some fines, it gets rid of some fines, and if any one of the experts want to speak to that, but yes.
Well,
yes, yes, Delegate Griffith. It does eliminate all fines and fees, not just the ones that are associated with pretrial, but fees that are associated with other things post-conviction.
And so I appreciate that, and I definitely don't want to you know, create undue financial burdens on folks who may not be in a great financial situation. But where I'm struck by this is, you know, and I want to say, I want to draw a comparison. In the police reform legislation that we were putting forward right now, for police officers who are being under investigation, they can be suspended without pay, which is the reverse of this, taking away their finances. But in this piece of legislation, we are going to not charge people fines and fees related. So isn't there a bit of a, I know we're trying to create equity in all things, and I support that, but in 670, we're saying we're going to suspend people without pay, right?
I would definitely, sorry, Delegate.
But here we're going to, you know, so those individuals are going to have to pay fees and pay bills, or not be able to pay bills with no income, because they're going to lose that income for the 30 days while under investigation. You know, on this side, we are going to eliminate those fines and fees. So I'm just trying to, I'm just looking for some, trying to understand, are we being consistent in these things? That's all.
Well, Delegate Griffith, I just want to say that I wouldn't want to conflate an individual such as a police officer who's taken a certain type of oath to the public with an individual citizen who may have been convicted of a crime. I think that those are two different institutions. Second, I would say that regardless of whether an individual has been convicted of a crime or not, copious fines and fees that, you know, bar them functionally from participating within society or something that, you know, we would definitely say we don't support. So one, those two things are very different. And two, we should still be focused on the public good of allowing individuals to, or for eliminating the criminalization of poverty.
Yeah, I think I'd also just clarify that fines and fees are different. And so you are not, it doesn't appear that the fines that may be related to underlying offenses or are part of your criminal code are being touched through this bill, that these are fees, and fees are cost recouping, right? These are ways that the government is adding, like the fine is punitive and the fee is an additional cost that is used to supplement normal budget practices for how you budget for government expenditures. And so by charging them back to individuals who come into contact with the system, whether those matters are, you know, people are, of charges are dismissed or whether they're adjudicated fully, is a budgeting revenue principle. And that is very separate than a fine, which may be still charged to a person for, you know, whatever underlying offense that they are convicted of. So just want to make a distinction.
And just so you know where the comparison was, fines and fees or taking away somebody's income while they're still going through the due process. Kind of that's the comparison I'm drawing there. I guess the last question for you, Delegate Davis, is just the physical note. I was reading the physical note. It's like 15 pages long and it's very, very complex. And it seems like a lot of burden will fall to the counties. Have you had any, and it's significant. Have you had a chance to digest that at all?
Yes, I have. And you know what? I take it as an indication of just how much we rely upon finding poor people. You know, we rely on these funds, and it's time to shift that narrative from funding the government on poor people's backs. I did see the note, but it's time to start to shift.
Thank you.
Delegate Bartlett.
Thank you, Mr. Chair. So I want to make sure I understand, because this is kind of complicated. I think this is for Ms. Sarathi Jones. Actually, I'm sorry. Let's before I go there, let me ask Mr. Stanford Fraser a question. You gave an example, and I lost the thread of your example just a little bit, and you were saying that that with respect, because I don't understand the criminal defense process with respect to pretrial fees, and then what happens. So first of all, when are pretrial fees incurred? And I think you gave an example of there could be continuances and those pretrial fees continue. And then you mentioned detainment. So I just want to make sure I understand what's going on with respect to the pretrial fees and the accumulation of them while the person is waiting to see if they're going to be found guilty or innocent.
Thank you for that question. I was giving an example for people that we colloquially call it the box, but if you're on pretrial release, we call it home detention, where you have certain times of the day that you have to be in your home. So it's not uniform across the state. In some jurisdictions, the counties will pay for it, right? The government will pay for it, but sometimes they say, okay, we can't use the county program or the government program, you have to use private home detention, right? And that's where costs can become associated with, and those costs are usually either charged by, they have numbers by the day, by the week, and by the month, right? And those have different rates. So then what we've seen, especially during the pandemic, is that a lot of cases have been pending for long periods of time, usually cases penned, right? But they've been pending for even longer periods of time. So we've had clients who have been on pretrial release for, let's say, 4 or 5 months, but the amount of monthly fees, they say they come to us as their public defender and say, hey, we can't afford this anymore. Can we try to change our pretrial options, right, through the court? And the process, we would go file a motion. And we've had some success in which judges are saying, because you've been successful, we'll move it to a less onerous component where you don't have to pay private home detention. But we've also had, some judges say, I don't believe you're flightless, I don't believe you're in danger, but we believe that you need to be on some type of, monitoring that in order to be released in the community. And if you can't afford that monitoring, then you have to wait in the jail pending your trial date, pending the adjudication of your case. So that's what I was speaking on.
So after the 4 to 5 months of the 4 to 5 months of the home detention, you could possibly be jailed. That's the point that I'm trying to get to. I need to understand that.
Exactly.
So let me just ask one more before you answer that. So originally you were saying that there's already a backlog. So before the pandemic, it could be 4 to 5 months. How long has it been post-pandemic in some cases? And then when does one get jailed while they're still waiting to determine their guilt or innocence? That's what I'm trying to understand.
Yeah, so if you're in a situation which you're having to pay for your own home detention fees or you're being charged for the home detention fees, once you cannot pay that, then you'd end up being jailed pending the outcome of your case. Like I said, it's not uniform across the state, but I can speak in Prince George's County. It might be 10 or 11 months since there's been a jury trial held in our county. I believe, according to the Chief Justice's order, that on April 26th, that's going to be open for every jurisdiction to begin planning jury trials. But now think of the amount of jury trials that were waiting, right? 10, 11 months ago, plus 10, 11 months of trials waiting, plus whatever cases are then arrested now. And that's going to add on to the wait. So this is a situation that can go on for months, if not years.
Okay. And Mr. Chair, may I ask just one more quick question to Mr. Stanford Frazier? Okay. So let's say House Bill 1331, had been passed. While a person, so the private home detention would still exist, or the home detention could still exist, but the fees in having to pay for that home monitoring device and all of that would not be incurred by that individual. And so therefore that individual may not later be jailed because of the failure to be able to pay it. Is that a proper chain of thought?
Yes, that's a proper chain of thought.
Okay, thank you.
Delegate Conaway, please.
Thank you, Mr. Chairman. Thank you, committee. To the maker of the bill, I like the bill. Now, what I want to say is, or ask is, who's going to pay for the home detention? The state? The state's going to pay for that? Who's going to pay for that?
Yes, Delegate. The state would. The Department of Corrections would.
Oh, thank you, Ms. Johnson. So, what's the total fiscal note on this bill? Do you know?
Well, it's relatively uncertain, specifically because there are varying different fees. But I do know that the Department of Corrections reported that there may be a $10 million loss, specifically in regards to home monitoring. But again, I would like to reiterate to the committee that these are fees that are associated to individuals. And I think that shows the veracity of the fees. $10 million to innocent individuals that have not been convicted of
before
crime.
you go too far into that, I asked you what was the total amount. So we have that 10 million. that's
That's as reported by the.
that's in corrections. How much are we going to lose in MVA fines?
Well, that part of the bill would not be, that's something that we would be amending out, just because that is a separate bill that we've done in the House and in the Senate. So that would be amended out. The two about, are you talking specifically about motor vehicle suspensions?
Okay, excuse me, Delegate Davis, are you planning on amending that out? I'm not against that being in the bill, and I would.
It's in a. It depends on how the other bill moves. Yeah, this is about freedom. This is Delegate Conaway. This is about people's freedom.
Sure, I agree. I agree with you, and I see that you're lowering the fines. I just want to know what's your total estimated cost and where we're going to get the money from. No idea. Okay, that's fine. Thank you.
Delegate Cardin, please.
Thank you, Mr. Chairman. Thank you very much for bringing the bill, Delegate Davis. I'm just actually, believe it or not, Delegate Conaway asked one of my questions. So my other question is, a judge right now has the authority to waive all fees. I think pre-verdict, post-verdict, they can do it already. And the question is, do you have any statistical evidence of how much the judge is doing that versus not doing it, and based on the capability to pay, so that we can see if, because one of the things that you guys said is that the fiscal note is unclear. Part of it might be because we don't know. I know that every time I ask if there's a financial issue with my clients, every time I ask, the judge grants waiver or reduction, every time. So I'm wondering, how necessary it is for, at least in certain circumstances, to make sure that it's being done. And is there a problem in certain jurisdictions where it's not being done, and that kind of thing? I'm just wondering if you have any statistical evidence.
I think, in response to your question, I think that when you hear some of the testimony from some of the other witnesses, you'll get a better idea of what's happening. It is not just with the judge. And we've had bills where we try to require the judge to ask whether you could pay before they jail you, or for there to be some type of how they do when public defenders, when you qualify for a public defender. We try to do that. It is so extensive, and you know what? If you still have this question after you hear the other testimony, let's talk about it some more. But what happens in the current system is that you get it from so many different angles, and so it's not just the court. Yeah.
I would like to speak briefly on post-conviction or post-trial fees. We don't have the data. We would love for more transparency in the data. Maybe that could be a separate bill, having those requests be collected and reported to the legislature. I can say it as a public defender, I have asked for my clients to have their fees waived, and unfortunately, it's not 100%. There have been times where the judges have acquiesced to our request, and there have been times when judges haven't. And we've even had situations where clients have to pay significant restitution and are able to, and we ask, well, can we then waive some of these associated fines or fees, right? And we've got denials. We've had times where clients are possibly maybe not even getting a sentence, but they're being put on probation, and they may have a substance abuse order. But that means every single time you're on probation, you get tested, you get charged, right? And if the goal is to not punish people for substance abuse, but to help them, especially when last year we had an increase, right, in overdoses. So we shouldn't be punishing people with substance abuses. We should be trying to help them thrive, but then we charge them, right, on probation to make those type of tests. So in my experience, like I said, this is anecdotal, right? We haven't collected it. We would love a bill to be introduced to collect that data, but it's not 100%.
And I would also like to just reiterate, Delegate, that some fees that are accrued have the judges would have no sort of jurisdiction over. So in terms of, room and board, in terms of, work release, things of that nature, judges don't really have, any say over in terms of how those fees get attributed.
All right. Are there any further questions for the panel? Seeing none, thank you all very much. Philip Westry, Davon Love, Crystal Williams. Michael Collins, and Tanika Richardson. And then we'll go to Michael Sanderson as well. Crystal Williams, I see you. Go ahead, and we'll let you speak for 2 minutes. Go ahead.
Thank you, Chair Clippinger and members of the Judiciary Committee. My name is Crystal Williams. As you heard, I currently serve as the Director of the Legislative Affairs Division for the Office of the Public Defender. And on behalf of our agency, and as you heard from my colleague Stanford Frazier, we are pleased to add our voices in support of the passage of HB 1331. I am available to answer some questions that the committee may have, as I know there were many questions about this bill, but I just want to say generally that we're here to offer the message that this is a critical step forward in eliminating the criminalization of poverty here in America and within the state of Maryland. The Public Defender's Office is particularly mindful of the harmful impact that unnecessary fees and fines have on our clients and their families. And particularly, we need to be mindful of juveniles who are charged as adults who also have families that they rely upon for most of their fees that are associated with their pretrial supervision as well. But the Public Defender's Office is important for us to highlight that we have a distinct role in representing individuals deemed to be indigent in the eyes of the law, specifically pursuant to the Maryland Code. They are individuals who are deemed to be unable to pay for necessary expenses of representation in their legal proceedings. The code further specifies that an individual whose income falls below the federal poverty line may be eligible for services through the Public Defender's Office. So these individuals are those who are already struggling to survive, to meet their basic needs, and to provide for their living necessities. While poverty rates may fluctuate throughout the state of Maryland, with Baltimore rating at the highest, at a little above 20%, and Calvert County coming in at the lowest at around 5%, equity and application of the laws should not fluctuate, especially for indigent individuals who are supposed to be legally protected and shielded from costly barriers in their legal proceedings. What this bill highlights and aims to ameliorate is the piecemeal and patchwork implementation of court-related fees and fines across the state of Maryland. As Delegate Davis earlier stated, it is time for Maryland to continue in the right direction for just and common sense criminal justice reform by taking the necessary steps to move away from and eliminate revenue-based implementation of criminal justice fees and fines. And so I want to thank Delegate Davis for her sponsorship of this bill, as well as members of the committee for their consideration and support of this effort. Thank you.
Thank you. We'll hear now from Michael Collins, please, for 2 minutes.
Thank you, Mr. Chairman. I'm the Policy Director for the Baltimore City State's Attorney's Office, and I'm here to express our office's support for this bill, and I'll focus on the elimination of costly home detention fees. It's important to recognise that the coronavirus is not just a public health crisis, it's an economic crisis and a crisis for our criminal justice system. Since the start of COVID-19, our office has worked to reduce the spread of the virus in prisons and jails, consulting with experts from Johns Hopkins University on the right measures to take. Despite courts being closed, bail hearings have been a constant feature of our city's criminal justice system. We have twice revamped our approach to bail policy to be more flexible given the current climate. Home detention is an option that prosecutors often ask for in bail hearings. Our prosecutors are instructed not to ask for home detention as an alternative to release, but rather home detention is used to prevent someone who would otherwise be in the jail system, which has seen serious challenges because of COVID-19. Because we have stopped prosecuting many low-level offences, individuals who receive a bail hearing often face more serious charges. And as we've strived to keep people out of jail, home detention has become a more regular option. The issue of home detention fees has therefore become more pressing. In Baltimore City, home detention is largely run by for-profit companies that charge between $11 and $17 a day, or around $100 a week. We estimate that there are perhaps 600 people on home detention in the city, meaning that private companies are potentially making between $2 and $4 million a year from the city alone. Some people may be paying these fees indefinitely, as mentioned, because it's unclear when the courts will fully reopen. And unlike the bail system, defendants whose cases are dropped or found not guilty don't get their money back. At a time of growing unemployment and economic uncertainty, such a financial burden can devastate families across the city. Forcing people to pay over $100 a week for their freedom is a recipe for disaster. The link between economic inequality and crime is well documented. When desperate people cannot afford their freedom, they take desperate measures to find the money to stay out of jail. The committee should know, therefore, that this bill is not just an issue of fairness, but of public safety. To promote public health and public safety, we must end
Mr. Collins,
criminalization of
please.
poverty. Thank you.
Thank you. Tanika Richardson, please, and then we'll hear from Nicole Hanson-Mundell, who missed the first panel. Tanika Richardson, please.
Yes, hello, thank you. My name is Tanika Richardson. I'm a state policy fellow at the Maryland Center on Economic Policy. Here at MedSep, we believe that every Marylander should be able to achieve their full potential in a healthy economy that offers a widely shared rising standard of living. We are also signed on to JOTF's testimony as well. So basically, given that Maryland's criminal justice system is disproportionately affects lower income communities of color, Senate Bill 898 would eliminate the majority of financial debts arising from court-related fines and fees. A recent report released by JOTF indicated that Maryland residents from impoverished communities unjustly encounter the criminal justice system. This report also outlines how extensive fines and fees related to interactions with the criminal justice system impoverish Marylanders, specifically, again, communities of color. The mitigations of these fees will sharply reduce the amount of debt that lower income communities face throughout Maryland. This will go a long way in reducing punitive damages for financially vulnerable Marylanders. For these reasons, the Maryland Center on Economic Policy respectfully requests that the committee makes a favorable report on Senate Bill 858.
Thank you. Thank you very much. Could we hear from Michael Sanderson, and then we'll go to Nicole Hanson-Mundell. Michael Sanderson.
Thank you, Mr. Chair and members of the committee. I'm Michael Sanderson with the Maryland Association of Counties. There's a pretty substantial local fiscal note to this bill, and the easy thing to do would be for the counties to oppose it. I want to give you some context for why we're here with the support with amendments, and it's basically philosophical. For a few years, my colleagues and I came before this committee on similar bills dealing with pretrial in particular and fees for pretrial and so forth, and we opposed those bills. Local fiscal note, we can't absorb it. We can't continue the programs and so forth. And to be honest, your committee deserves kudos. You threaded the needle and worked this out. You took two separate issues, you put them together into one bill, and you passed that bill out of this committee and out of the House this year with our support. From the point of view of these local programs, maybe there is a carrots rather than sticks approach that can do this as well. I realize that this is a big lift. It's got a state fiscal note, it's got a local fiscal note. You'll hear from our wardens, and I think those are legitimate concerns that you've got to balance. Our support with amendments is basically saying, we'd love to work with you to see if there's a way to do what you want to do here. I understand the policy goals. I also know that the fiscal note makes it difficult. If there's a way to turn this into carrots rather than sticks, we'd like to be part of that effort and make something happen. I don't think this bill, as it sits, is the answer, but rather than just blowing it up, we wanted to say, hey, this committee's got a track record of working stuff out. We'd love to be part of that. Thank you, Mr. Chair.
Thank you very much. All right. Nicole Hanson-Mundell.
Good afternoon. The executive director of Out for Justice for the Record, a nonprofit organization that advocates for the very individuals that we all are talking about here. I don't want to be repetitive because the arguments of my colleagues were so on point. I can't help but, talking about the fact that, judges barely, hardly ever waive the fees that are unknown, right? Oftentimes, they don't even know some of the additional fees that will incur from whether it's a charge or whether it's dealing with the MDA. Many times, some of these fees occur after. I'm literally in the middle of helping one of my members with NBA fines from the blowing machine. I'm sorry, I don't have the right word to say it, but I think you all know what I'm talking about. When you first time DUI, never got a DUI before, and he has a disability. And I think, you know, it was not considered. Shit.
Well, poor Nicole. I will admonish staff for failure to use the bleeping machine for today's hearing. And we do appreciate hearing from Nicole. We're going to go ahead and take questions for the panel right now. If she comes back, I'll give her a little bit of extra time. But these things happen. All right, Delegate Rachel Jones.
I just had a quick question. I do want to thank Delegate Davis for bringing forth this bill. I just have a quick question for Ms. Williams. You listed some statistics, and I know that you only have 2 minutes, so you were kind of going a little fast there. But you mentioned Calvert County, I think. Can you give or speak a little bit more about those statistics, please? And if you could elaborate on that, I'd appreciate it.
Yeah, so my point of highlighting the disparity, or I guess the distinction in terms of poverty rates across Maryland, is that they vary broadly. And so Baltimore City has a poverty rate, I believe the last number that I checked was about 21%. And for, I believe, Calvert County, it was as low as 5%. I believe Maryland as a whole, the entire state stands at about 10%, or hovers around between 9 and 10%. And so that just shows that there is a distinction in terms of the poverty levels across the state, yet you have these fees and fines that are imposed throughout various counties, various jurisdictions, equally to indigent individuals that we represent. And so we represent a population that falls within those categories, whether it's the 5% or the 20%, that is our client population, and they are subject to those fees and fines. And so that's what I wanted to highlight.
Great, thank you.
I'm back, Mr. Chair. I'm sorry. The digital divide is real.
Yes, it is. We will hear from you for, let's give you another minute.
Thank you.
Let's try to make this the radio safe version, all right?
Yes, sir.
All right, 1 minute. Finish your remarks.
Sorry. You know, I said all that to say, I have so many members who come in here and need support for many of these probation fees, many of these MBA fees, traffic ticket fees, all of these fees that they're already on very limited income. And it is very hard for them to try to stay out of prison or jail, knowing that they have to accommodate these fees. Probation and parole, you have to pay your analysis fees. These are individuals who are indigent, as many of you all know. My member is literally still paying for the machine to be in his car. He's not even driving his car for a whole year. His driver's license was inactive, but the fee was still occurring. Now that I've been able to advocate with him through his state elected official to be able to get back on the road. He's still having to pay fees in which, you know, it was not his fault that he could not blow into this machine because of an upper respiratory issue. And so I say all that to say that, you know, we really have to make sure that we're protecting a community and making sure that community is safe. And the one way to do that is to ensure that people are not trying to rob Peter to pay Paul, and they're not trying to break additional laws in order to pay fines and fees for some prior offense that, you know, that they were convicted of or whatever. So thank you.
Thank you. No, thank you very much. Are there further questions for the panel? Seeing none, we do thank you all for your testimony. We apologize for the difficulty with the digital divide. We feel the same way about it sometimes. And we thank you all very, very much. That concludes the testimony for House Bill 1331. That concludes the testimony for the legislation that was going to be heard today, Tuesday, the 9th of March. At 5 o'clock, the Family and Juvenile Law Subcommittee will be meeting and discussing several bills. They will start at 5 o'clock. There's a subcommittee chairs meeting at 7 o'clock and a voting session tonight at 8 o'clock. And the bills that we're voting on have been posted online. I will say that it's my understanding that the single bill that we had set for a hearing on Thursday, this Thursday, the 11th, has been withdrawn. So there will not be bill hearings this Thursday, the 11th, at all. With that, we thank you all very much for your attention, and we are done for the day. Thank you, except for the subcommittees. The